Hello, I'm David Roger, General Counsel for the Las Vegas Police Protective Association. About a month ago, an officer contacted me and asked whether a Clark County Detention Center policy that requires officers to get a search warrant to seize property which is in an inmate's property bag is lawful. We discussed in a video probably a couple weeks ago that the U.S. Supreme Court has held that inmates do not have an expectation of privacy in property that they were arrested with and is in Clark County Detention Center custody. Officers are not required to get a search warrant. In that particular case, a detective found that an inmate had been communicating prior to or during the crime, knew that the inmate had a cell phone which was booked into their personal property, and wanted to get the cell phone in order to get a search warrant to search the contents of the cell phone. And jail personnel refused to turn it over without a search warrant. And so we got a copy of an email laying down the law by Captain Schmidt. And this email, which I'll include, is dated May 25th, 2023. And this is the policy that Schmidt laid down. LVMPD investigators can come to CCDC and search and collect items of evidentiary value while the property is still located in pre-arrest by requesting to do so. So that is when it's on this side of the counter. When the property is sealed and it's on the other side of the counter, Captain Schmidt has imposed a different set of rules. She writes, once the property has been inventoried and both the inmate and booking staff signed for it, the bag is sealed and is placed on the other side of the window. The detective must obtain a search warrant to get the property. It's almost like CCDC is the Four Seasons. And once you get your baggage claim check at CCDC, you have a right to privacy. Insanity. This is the U.S. Supreme Court in U.S. v. Edwards, not Captain Schmidt's law, but the United States Supreme Court. This is a case that was handed down in 1974, before I went to high school. And in almost 50 years since this decision, the U.S. Supreme Court has not backed down from its decision that inmates do not have a right to privacy in their property while they're at the jail. The U.S. Supreme Court discussed, indeed, it is difficult to perceive what is unreasonable about the police's examination and holding as evidence those personal effects of the accused that they already have in their lawful custody as a result of a lawful arrest. They went on and discussed an appellate court decision, Caruso. Caruso is typical of most cases in the courts of appeals that have long since concluded that once the accused is lawfully arrested and is in custody, the effects in his possession at the place of detention that were subject to search at the time and place of his arrest may lawfully be searched and seized without a warrant, even though a substantial period of time has elapsed between the arrest and the subsequent administrative processing, on the one hand, and the taking of property for use as evidence on the other. This is true where the clothing or effects are immediately seized upon arrival at the jail, held under the defendant's name in the property room of the jail, and at a later time searched and taken for use at the subsequent criminal trial. The result is the same where the property is not physically taken from the defendant until sometime after his incarceration. Inmates don't have a right to privacy in their personal property when they're lawfully arrested. They don't have a right to privacy in a plastic bag that seals their belongings until they are released from custody. And by the way, in 1984, 10 years after this decision, the U.S. Supreme Court in Hudson versus Palmer held that inmates do not have a right to privacy in their jail cells, and that jail COs may randomly toss or search the inmate's cell without a search warrant. And so if you take Captain Schmidt's email to its logical conclusion, then not only do inmates have a right to privacy and are entitled to have a search warrant issued before their personal property can be turned over to the other side of Metro, the POs, but COs have to get a search warrant before they can search an inmate cell. What a ridiculous thought that would be. But that is the logical extension of Captain Schmidt's email. So hopefully, for the sake of detectives who are trying to work cases and put cases together, Captain Schmidt will reconsider her mandate to the jail personnel that fellow officers aren't required to get a search warrant to get property they already had in their legal possession at the time that the individual was arrested. And if common sense does not take over, does not prevail, then my suggestion to you, patrol officers and detectives, is that when you arrest an individual, impound everything. Take the phone, take the wallet, take all the property and book it into evidence in the evidence vault. And we know that Sheriff McMahill isn't going to require you to get a search warrant to take property out of the evidence vault. Please, those people who are in charge, let's have common sense prevail and not stand in the way of officers who are trying to protect the community, who are trying to make cases to bring people to justice in our courts. If you have any questions, feel free to contact me at droger@lvppa.com. I'll include both the U.S. versus Edwards case as well as Hudson versus Palmer, so people can read these cases for themselves. And of course, Captain Schmidt's edict that she issued on May 25th, 2023. Thank you.
111, 110.